Now we are going to participate together with the Minister of Justice, Mr. Serrara and Mr. Botero, on this panel on legal security challenges and solutions. First and foremost, I would like to thank FASE Corda and its president, Roberto Botero, for this invitation in order to have a dialogue on these topics of common interest. We have agreed on a dynamics in which, at first, and I'm sorry, I'm going to mention my name first, but I'm going to make a brief presentation on the problems of legal security and how is this reflected in different parts of economic sectors, and then I'll talk about the impact on the insurance activity regarding specific topics. Then Mr. Luis Jaime Salgar is going to present on legal security from a more profound standpoint, on how is this faced by law and which are the potential alternatives in order to solve this real problem in our legal system in Colombia. And then the minister can give us her opinions on the ideas presented by us, and we'll talk about public policy when it comes to justice and which are the main challenges for coming years. At the end, if there is time, we could have a debate. Let's talk about some aspects on legal security. This is a legal principle, and the idea is for citizens to be certain and to be able to foresee the different regulations that regulate their activity, and those decisions that solve their problems. So the regulatory system, the legal regulation is stable, and it gives rise to trust. Legal security enables for citizens to trust their institutions. From its effect standpoint, legal security avoids inconsistencies in the regulatory system, and inconsistencies given lack of clarity in supervisory entities strengthens economic activities, and it provides resources to the extent that provided there is stability in the rules of the game, investors are going to know what to expect, and they are going to have a reliable return regarding their investments. In the part to the right, there is a concern that was part of the joint industrial survey of Andy and businessmen, whereas in their sector during the past 2 years have had significant regulatory changes, and businessmen, 75%, 3 out of 4 said yes, that in the last years their sector had important regulatory changes or modifications. Which are the problems that we have identified in terms of legal security? And here we're going to refer to develop them here. They could be of your interest. And these are general factors, and we'll see the incidents that they can have in some important fields of the operation of insurance companies. These are the constant changes in the regulation. The regulation is not a stable regulation, it's volatile. There is a lot of lack of security of who regulates, if the law or what. And there is also the problem of the speed or agility with which disputes are solved in the area of contracts. So in order to give stability to this, and the stability of investment is to know if there is a dispute in the contractual standpoint that will be quickly solved. Thirdly, we're going to give some example, and it's the role of judges in a society such as ours, based on what's set forth in the Constitution of 1991 with respect to the role of the constitutional judge and a creative judge that sometimes applies more principles than existing rules. And fourth is the so-called tutela against some judicial sentences, as judicial sentences should transfer to judge things. That is, that a firm sentence cannot be discussed, and it gives the parties clarity on the decisions. But our system enables to appeal those judicial sentences, and this gives rise to a lack of security. And another case that affects the insurance sector is that some state entities, mainly control entities, have extensive interpretations which have significantly affected the economic activity, as is the extension of fiscal responsibility, excess and constant changes of regulation. And there is an important topic here. We always assign the responsibility to legal insecurity to judges, and mainly to the judge that is creative. So if you take a look at the bottom in that same survey, I told you about it, businessmen were asked about the origin of the decisions, regulations, or sentences that have an impact on their companies. 86% said that decrees and resolution, 67 laws, 37 decisions of sectoral agents, 25 the Constitutional Court, and 22 judges. So if we take a look at that statistics, we see that there are some legal decisions and they create a lot of legal insecurity, and part of this is in the regulation, and who is competent for this. So there is a permanent issue of regulations that give rise to volatility, and it affects the source of law. So what forces them, if it's the sentence, the resolution. So we have things we have to work on. The second topic, that Gloria Maria, when she was part of the corporation and she worked in a responsible manner, drawing the attention of this problematic, and it's the time that it takes to solve conflicts in order for a businessman to make effective its rights by means of a contract. The study done by Doing Business in 2016, it warns that in Colombia process, in order for a contract to become effective, takes from 3.5 years. That compared to Latin America, it takes a long time, and compared to the statistics of OECD, it takes too long, and the cost is about 45% of the claims value. There is a problem. We tried to solve it with another process code, introducing orality here and saying that a legal process should not last more than 1 year in the first instance and more than 6 months in the second one. It was discussed that what happened if the judge had that process for over a year, and some courts said that what follows from there on it needs to be annulled. So, I mean, but here, if the judge takes more than 1 year, it just creates sanctions at other levels, but it's not avoided. Then the third item is the role of judges. We are going to refer to constitutional jurisprudence. The role of judges is necessary to for solving conflicts, and in order for citizens to have clarity on the rules that regulated, and also the constitutionality control, whether it is abstract or concrete. That's very important. We are not going to repeat this, but there is a debate on which should be the scope of the role of the Constitutional Court in the compliance of its competencies. We've seen many cases in which the sentence of the Constitutional Court have significantly extended what could be the text and the sense of the laws. The decisions of the Constitutional Court are not predictable or not consistent in some circumstances. Later on, we're going to see some variability in the Constitution, which have affected the economic activity. And as to constitutionality control, it strikes us that in an excess of a dogma, some sentences are issued not only of the different rights of the law and all the, if it's to appeal, and if it's effects to the past or to the future. So the contribution that could be made to legal insecurities is indeed very important. Some cases that have led to controversies in jurisdictional sentences that have affected some economic sectors. One is the competence of national and territorial authorities when it comes to mining. There are 3 constitutional sentences that establish different parameters on Article 37 of the Mining Code that bans regional, sectional, local authorities to determine zones of the territory that will be excluded from mining activities. Regarding that rule, if it was one of local or national nature, there was some controversy. We had one of 2012 that said that the rule could not be enforced, but they say yes, that it cannot be enforced because they have to contact the Environmental Authority and Regulation 2016. The sentence 2C73 declared this regulation not enforceable. So 3 sentences within a 4-year range with different decisions. The second topic is that of popular consultations. You know that is a mechanism. Popular consultation is for citizens' participation by means of which some important decisions could be consulted to citizens so they can pronounce themselves if there is something of state, municipal importance. However, there is no clarity about in which cases a popular consultation is required and which is the authority that has the decision with respect to non-renewable natural resources. We have the prior consultation, and all of us here have heard about the difficulties that this topic has. And even though it is not a Colombian thing, it exists in many parts of the world in which citizens and certain communities must be previously consulted when they are affected by hydrocarbon exploitation, infrastructure projects. In Colombia, we have constitutional sentences in which, even though the established regulation that was the responsibility of the Ministry of the Interior to determine if a given paperwork was met, the Constitutional Court said no because it extended that criterion. It established a criteria on the need to assess direct effect on this, negative effect. So it was considered that the people that were living in the reservation, they had to be consulted on this, but this was modified and it was considered a holistic effect, and not only it included the territory of the reservation or any near territory in which the community will have some sacred topic or ancestors tradition, and that changes the rule in a significant manner. The fourth topic that is important to highlight is that of tutela against judicial sentences as a factor that gives rise to legal and security. That's a value that has been very relevant in law, is the factor of judged thing that sentences have.
It should be a judgment that will close the conflict. It could be a review or cassation. It may be you can go to an institutional judge to see if a fundamental right was violated, so the proceedings never end. I don't know if you have an arbitration where you have the arbitration sentence, and then you have the another resort, and then you have tutela, and then you have another tutela, and four paperworks, and finally the decision is really firm sometime after the first decision was adopted. And finally, in an aspect that is related to insurance sector, it's some actions by the controller's office because they have opened some investigations about some assumptions that before didn't have that scope. There is a doctrine of the controller's office for tax responsibility of public resources, saying that the insurance company may be indirectly liable. So it can be a solidary responsibility without looking at coverage or exclusion, and for an undefined time. This is something of concern, and it should be solved eventually on the regulatory side. On the other hand, there was another concern. Some years back, it was a concern, but then it was reactivated. We have the undue use of resources of the social security system for fees to middlemen, that for a value of 431 billion pesos, and this is an important contingency for the insurance companies working on this side. In the 4 minutes that I have left, some specific assumptions with respect to insurance. All of you, I am simply going to make a summary about the impact of these legal insecurity factors in a special branch that has to do with the annuities. It has to do with the issues complex as a factor that was set in 2008 or 9, the standard to issue a decree. The decree was issued 6 years later, so there is a juridical insecurity. We're referring basically to judgments about tutelas that affected the rules of the game in these annuities and insurance, and the calculation to have the invalidity and pension 50 weeks or in the last 3 years. It depends on the structure of disability, or there are some important changes there, making more flexible so that the parents may have access to survivals, and it's a legal standard. So the parents were depending of the disease child or with a disability, so they deleted that request. The fidelity, there were 2 judgments that considered that it was to contribute to the system at least 20% in the last year, so etc. Not only these 2 judgments considered that it was regressive and they took it, but a tutela of 2011 apply it with retroactivity, contradicting what we had before in the area. The Supreme Court in 2007 said that this was not be a provision, and this is one of the, because with time you can consolidate situations. And finally, a judgment that have been studied by Basecolda, and this is T064 of 2016, that provided a dramatic child, a child with a health difficulties, son of a person that had a disability of one hand, and grandson of a person that had a retirement pension, and that person, the grandfather, died, and the father asked for the extension of the pension, and it was given to this grandson, extending or changing the rules of the game. Of course, that will generate impact. And Fasecolda has studied this, and in the case, in the scenario that will be the less wide scenario, will have a cost of 400 billion pesos if that requirement would be extended to all families that have these grandchildren with disability. Where do we get that money? From public resources, and that will stop other people to receive pensions. With respect to life insurance, simply we are referring here to a problem that we have had with the jurisprudence, and that is the modification of some rules. As you know, if the insured was not loyal in the statement, that could lead to a null contract. But the law has considered that insurance company has some burden, and that has a confirmation burden. So the person, even if they had a statement in a given sense, but if the insurance company has the doubt, they can request for a medical examination to see if the person had the issue or not. If they didn't have that confirmation burden, there is no possibility of asking for the nullity. And finally, I'm going to adjust to time. This is a concern that I have had of some time, and I'm transmitting this. And I think that the allocation of functions to the supervision authorities has some positive things, or some specialized judges that know about this. At the beginning, they were looking at the celerity, but nevertheless, in the particular case, the jurisdictional functions respecting the work done, I think that they have a concern, because if there are judges of actions of the insurance, someone that depends on the financial superintendent, that have also the inspection, the supervision, control, and surveillance of these insured entities. How can you have autonomy and independence that have been important values when, for example, a judge that depends on the supervision authority, it is very difficult to go against the doctrine of the superintendency. So that could lead to, and the minister has been working in a project in that sense, she will confirm this, and it's a possibility to create a special jurisdiction. In Colombia, we have a special jurisdiction. We have the family jurisdiction, but it is a wish to have a commercial jurisdiction, so you can decide conflicts of traders, and looking at the protection of the consumer. This is part of the contractual action, and we have to value what it will cost to have an entrepreneurship action. So I'm going to give now the floor to Dr. Salgado.
A ver esto. ¿Cómo manejo esto?
Work with this. Looking at the title, of the forum inviting us, I would like to talk about the legal security. I would like to put the legal security in perspective in order to analyze it in a wide manner, conceptual manner, so as to draw some conclusions that are of general nature. In order to continue with this talk, I will be talking about 4 topics. I'm going to make general considerations that will be short because he already analyzed some of the relevant aspects. I would like to refer to causes of legal insecurity. I would like to analyze the challenges of a conflict society, and I would like to propose some solutions. With respect to the general considerations, Mr. Solarte was telling us that legal security is the fact of having certainty, of knowing what are we dealing with, and this is important. Legal security not necessarily means justice. We may be certain that we're going to comply with a standard, but it doesn't mean that it's fair. So if it's legal security, it's a important value. Legal security must have other values that will give some weight. And legal security is not just efficiency. We understand that efficient is the problems to be solved, and the problems are solved fast. We do not have legal security, at least in the sense of achieving fair solutions. Nevertheless, in a democratic society, we value legal security. Legal security is providing us with time perspectives. We can adjust our decisions with a forecast. It is determining in general for the productive activity of human activities, and it's important specifically for investment for productive activities that extend in a long term. I'm talking about infrastructure, specifically a road, an airport, which is the forecasting time. I'm talking about financial contracts. A credit will be for 10 or 15 years or more. I'm referring also to insurance. When I'm 25 years old, I have an insurance. I'm not buying with the insurance with the expectation that it will last 1 year, but to set up a relation with an insurance company, and I'm going to maintain it with time. So when I'm 40 or 50 or 60, I will keep my relation with this company, because if I go with another company, I will have some pre-existence. So to maintain this legal security is very important. Why? Because it will provide us a future vision. It will allow us to locate ourselves in time, within time. What causes legal insecurity? Inflation not only changes, we have many standards, and the ones that we have, we change it permanently. We have a poor quality standards. Both the legislature as well as the regulators, they make quick decisions without the adequate weighting, without sufficient quality. So we have overlapping in mining sector. We have the national authority granting licenses, the environmental authority, and the local authority as well. We have a problem of a slow administration. We have a legal uncertain and contradictory ones. So we have decisions that are not based in positive law. And I'm not going to read all these endless lists that I brought with me. There is another component about legal security that we should take into consideration, and that is the one related to a conflictive society. What is a conflict? A conflict is not being in agreement. When I'm not in agreement, I'm looking for that. I will find some room. In a democratic society, we do it through the legal channels. Among others, the legal actions. And in this country, the legal action has been a mechanism for solving social conflicts, of expressing divergence. This is important, but it generates difficulties and problems that must be organizedly solved. We have what we thought that it was applying for the hair, it applies for the son, a person that is being raised, not the real son. We thought it was for 1 year, but it applies for the one that was due in 377 days. So this growth of rights, this expansion of rights generates a lack of security and collusion. Who is the right? It's the right of communities to protest and to demand some claims for the infrastructure company. The company that is making the infrastructure company, or the company is entitled to generate social development. So we have some difficulties there. And of course, we have the social protest scenario that is channeled in the democratic society. How can we solve this? As you would say, how can you eat all of this? I'm going to propose some solutions that help to look at alternatives. The first, we have the norm solution. I want to analyze new institutional dialogue scenarios. I'm going to make changes. These are just speculations. I want to refer to the main role of trade association and civil society. As you know, the Minister of Interior and Minister of Justice that is here in present, they submitted a constitutional reform project or a bill trying to adapt or adjust justice administration to improve. There are some other projects. There is a project by Cambio Radical and the Centro Democrático. So it's a very sensitive issue, and this is something that leads us to think. But among the proposals made by the governments through the Ministry of Interior and the Ministry of Justice is to adjust the decision statement. At the Constitutional Court, they issue judgments that are communicated by press, and they postpone the publication of decisions formally adopted for a limited time. Today, they publish the judgment related to application rules of a peace agreement, 350 days behind, the decision making and knowledge. This is silly, totally silly. So, of course, it is necessary to improve that. The project is aiming at strengthening this and to strengthen the courts. And all these sentences that is the task. The task is to say, to clarify the right. Nobody will get to a legal decision, but you have to end with you have to end the solution. And you have to look at the courts. You have to look at we have to look at the courts that have not only different positions among them, but you have to have differences within themselves. There is a decision of the Constitutional Court, and at the other day they will adopt a decision that is different. So unifying role is very important. And the function of the president, that is the trajectory and the understanding that we have had of the law. This antecedent or precedent is the means so the judges will illustrate on how we understand the standards, and they define their meaning to make possible for judges to take care of this antecedent. It's one of the success of this reform. And third, we have to delimit tutela. The project proposes to limit tutela. I do agree with that. It is very complex, subject to a greater polemic. They say that through this we were going to harm tutela. I do not agree. I consider that we cannot have rights, unlimited rights or uncertain rights. tutela has huge advantages, but it's over growing. The project has some themes that are important. To allocate competent judges that will be in charge of solving the problems and not just any judge. There is a specialization task. There are some questions and mechanisms to clarify the way the tutela operate. The decisions of the has been quietly controversial, really controversial. Do you remember the tutela action? They were saying that there was a tutela with the traditions. The court declared that that standard was not constitutional, and they say, "Oh, we have to check this through tutela." So. The court has generated this situation of uncertainty to define the way the tutela operates. It's determining action. We must have a tutela eventually in clear conditions, the limited conditions, specific conditions, not the way we see it now, where tutela is a parallel process that makes no sense. It's not in the constitutional reform. It is something that has generated a controversy. As you know, we are looking at the court in health. They have made decisions where specifically the government, you have to say, oh, this cannot be the case. This is a serious situation. And they provide some guidelines about what should be done by the government so these problems may be solved. In some cases, the judge has substituted the government as a formulator of public policy. That is serious because they do not have the tools to do it as the or technical government bodies have when they have to carry out that function. So yes, provided it's to set basic parameters, not to set public policy. Another topic that is highly complex, that is not based in positive law. This is what has been written, and we can adjust to that. Judges have interpreted the standard in a way that goes beyond what has been written. That goes from the pension fund, from the grandparent to the grandfather to the grandson, where they cannot pay a credit, and then you have some facilities to do so. The child that the parent doesn't pay the pension, and the child that cannot be gotten out of school. So maybe much of that is important. I'm not opposed to that, but it's important for the decisions to have some clear criteria behind, so it will make people and the social stakeholders to understand where are things heading to, and that will provide us with legal security. There are some other things that I would like to say. In this country, anyone can submit a bill. So the possibility of presenting bills, it's the open list for elections, and anyone can do this. So you do not have the construction of the collectivity, and that's why we want institutionality. Likewise, public actions in constitutionality. If you feel uncomfortable by a law or an act, you can go against it. And I think this is a too strong power for any constituent. In other parties, you can go against the standard provided you have a minimum number of people. That will make the debate not to be an individual debate, so it will be a collective construction. So it is important to review the margin of judicial or legal autonomy, the possibility of the judge to make a decision because of their knowledge without any pressure. That is fine, but what is not fine is that the judge is a separate person that will make decisions without the context that are outside of the social dynamics. So, what is the judge framework? Can the judge go beyond the law? What are the conditions? Which are the rules? How can you solve complex cases? Which are the rules of assessing legal function? This is a very important topic, and we need to work on that. There is some resistance. It is important to value the judge, and it will be positive to have this function to be exercised by third parties, including the possibility to be assessed by the national government. We have to think on an institutional dialogue. Judges, and specifically constitutional judges, make decisions that are complex and that encompass the public agenda because they set policies. The constitutional judge modifies the rules. They have a judge that will make a decision in a separate way without considering the important stakeholders. I think that is wrong. We should have some conversation, dialogue between the judge and the administrative authorities, social stakeholders, so as to build wider solutions. And once again, evaluation mechanisms of judges. Third, technology. We see today that artificial intelligence has made some progress and they have some tools to detect the preferred decisions. In that field, artificial intelligence may go along with the judicial action. The decisions, legal actions or judicial actions or decisions are besides normal decisions. Artificial intelligence may replace some of the judicial actions in decision making in aspects where we have recurrent actions. So an algorithm that will be there with the judicial decisions, it's not different from the algorithm that is used by the database companies in order to build the financial scores. So if you can do it in the credit allocation, traffic control, political preference definition, you can have an algorithm for judicial decisions. Finally, I would like to talk about the trade association function. I think it's possible for the associations to build solutions that will be efficient, that will avoid to incur in constitutional problems. I'm giving you an example. In the credit sector, as a result of some of the constitutional judges,
we advanced in collection practices that are the most efficient and the most protective ones. That is to collect the overdue portfolio, and at the same time we made a progress in protecting constitutional rights. This has been done in the sphere of employer-employee relationships. The differences are solved not through the judge but through direct negotiations. The same thing could be done with the SO8 insurance. Trade associations are in the possibility of overseeing judges' decisions, legislators' decision, and of informing what's happening with them. Obviously, they do it, but we need to have like a dissemination task. And thirdly, markets defense. And I'm specifically referring to decisions that by wanting to protect, they actually remove protection if the controller's office sanctions the insurance company that had insured the directors of any company, and it creates an accident beyond what's covered by the premium, which is the rational decision of the insurance company. Well, they are no longer going to sell the product because it becomes risky. So we all lose the opportunity of counting on that service. The AN is exceeding the coverage ratio of those that buy the policies. So, I mean, the product has been restricted, it becomes more expensive. After UPAC, credit, housing credit was significantly restricted, so that trade associations have the possibility of defending and demonstrating the effects of those decisions that instead of protecting some, they protect a group of people, and that's bad for trade associations and for society. Thank you very much. Thank you to Mr. Solarte, Mr. Salgar. Well, the minister, she wanted to listen, she wanted to make notes, and she has freedom to present a statement on these topics of legal security that perhaps are going to be framed within the constitutional reform project presented on behalf of the government. Minister, we really want to do my homework. I cannot ignore the importance of the topic on legal security for the development of Colombian businesses. I coach many businessmen in concrete analysis of legal insecurity that exists in Colombia. President Duque, in his government program, which is based on three basic axes, which is legality of entrepreneurship in order to find equity in the country. Justice is crossing those three axes. Obviously, without justice, we are not going to have legality. Entrepreneurship without legal security cannot be attained. And if we do not reach the legal empowerment of poor people and the search for equity of all citizens, we are not going to achieve that social goal. So I have some complex challenges for the three main axes of the government program. What we have called justice reform is a process, is not depleted with the legislative act that we presented last September 3. We have a much broader agenda that consists of constitutional provisions, a legislative agenda, but mainly in a management and transformation agenda of infrastructure as well as of technology of the justice sector. 4 years is very little for the transformations we're aiming at. So I think that we are only going to set the foundations for a modernization path. We hope to be sufficiently strategic in order to remove a culture and a very heavy states machine that doesn't allow to reach those objectives in an expedite manner amongst transformational management and technology topics. We are trying to reach the virtualization of justice through some strategic paths. For example, we are coaching and looking for resources for them in order to work together with the Constitutional Court in the digitization of all the tutela processes and using artificial intelligence for the selection of tutelas in the Constitutional Court. We are resorting to international cooperation, hoping to the reactivation of the economy in order to obtain the needed resources for that transformation. Moreover, AI reached Colombian justice. The prosecutor's office has the Watson prosecutor. The general prosecutor has put this in place and has been able to complete all the way to indictment many crimes such as thefts, and the Watson prosecutor becomes more effective, and it is going to be of great help for justice. Moreover, we are trying to establish the regulation in order to create the DNA bank that has been a fundamental transformation in the European Union for investigations, and not only of homicides, which is related to the theft of households. And the disruptive technology that was mentioned by the representative of CAF is part of justice. We are lagging behind, and there is no way we're going to catch up. We are not going to reach the traditional file and the justice of the 21st century, but hopefully we're going to be sufficiently strategic in order to take those leaps and to reach the level that is being reached by technology. If we do not do this, and we're going to see 10 or 15 years go by, and this is going to be imposed, such as Uber, and we are going to be able to have virtual judges underlying the judge. Technological changes are amazing, and we are trying at least to strategically plan to see how can we help in order to reach some transformations. Moreover, we're looking for resources. We are trying to establish an investment fund in order to catch up regarding the infrastructure of the legal system. We cannot continue with those courts that you have in your mind that we see in the newscast that goes against justice. And that's why our citizens do not believe in judges. And it's necessary to catch up in infrastructure. When it comes to the legal topic, without me thinking that to create rules will transform reality as we usually tend to think, but sometimes it is necessary to adopt technological changes on an ongoing manner. We are going to try to reorganize criminal policy, and to do this, we have to go over the criminal code, and we have to rationalize sentences. Since we are so used to punitive populism, we have made a disaster with criminal justice in Colombia, with the consequences that my ministry has to go through, which is the problem of overcrowding in jails. And what's happening in jails is not human at all, and it's something we feel shame of, and we're living, and these are not human conditions. Hence, it is necessary not to put an end to the state of unconstitutional things. I think the public policy should not be dictated by that, but those warnings are very important. And in few days, we are going to have another warning in that sense. And we are like in a straitjacket because we have low institutional power to rebuild the jails that we need in the country, and we continue having new rules, and all the Colombians want to see the bad guys in jails. But we have to fight against that culture. Without that, the inefficiency of the state, which with against this lack of resources. And hopefully this will not affect this, that we cannot achieve those transformations in law, because every day we are sorting out problems in jail as price intoxication, and also we had to see who could we appoint as director of La Picota jail because of a high level of corruption existing in the criminal system. We are going to change the judicial career. We are going to change the rating of judges. We're going to have a more cross-cutting career. There is no possibility for judges to be promoted in a vertical manner, but in a horizontal manner. So there is the desire of having an incidence on the transformation of the schools of law and the training of lawyers and judges. Among other regulatory proposals that we have to work on, we are aware that the lack of legal security is resulted by the legislative hyperinflation, and we are in the second debate regarding a bill that it's removing almost 12,000 laws because these laws are incoherent, they are not being used, they had been poorly drafted. And that law is close to a regulatory production regulation to see if we make this reasonable, as was expressed by the Minister of Transportation. In many sectors, we are improving the state's regulation. This is a reality, and there are jurisdictional functions all over the place without any control whatsoever. This is a desire I had when I was in the corporation to start learning about those jurisdictional processes to see so we can exercise control over them at the Ministry of Justice, and to see if it's valid that the regulator will at the same time have will have jurisdictional functions. So we have to embark on that task if urgent things enable us to do that. As to the constitutional part, we have presented a justice reform. It is indeed a difficult process. You know that this is the 10th time that since 1991 we've aimed at a justice reform since the superior court process was established. And I remember that he worked with Hernán Echavarria, who said, how can we create a collegiate to manage justice? And the Interinstitutional Commission of the Judicial Branch was part of the bylaw, but it was because of a management of a business group, if I'm not wrong. That was like in 1992, 1993. In other words, since that moment, we became aware of the fact that the constitutional design of 1991 had mistakes and deficiency. So what concerns me, or my main interest, is to transform the regulatory and management body of the judicial branch, because it has been useless to propose some reforms when we do not have an adequate regulator that will make this effective. In the Superior Court, there are no people with proper profiles to do so. And in addition to this, the design confused government and management functions. So we are trying to correct that design. We have sentences of the Constitutional Court that do not allow for us to do what we want to do because we are very limited. So we have embarked on a process, and that was a requirement of President Duque when it comes to the social dialogue, to start building this justice transformation with the judicial branch and with other actors. I've been working with them for the last month and a half, and if you see the interview of Mr. Guerrero at the Espectador Journal, you've seen that we have reached some common items. Without any doubt, there are three projects of constitutional reform. We have engaged in a negotiation process with all the political parties. We started this yesterday. And actually, the only thing I see is that we are very close to many agreements. The diagnostics are clear, and we have many common elements. And I think that from here to Tuesday, we are going to attain a unique presentation with respect to justice reform. We know that this constitutional reform do not sort out people's problems. And that is like the excuse presented by those opposing to this. Obviously, no, but we need to modify that regulatory body. It has three main axes: legal security, and Mr. Salgar mentioned some of these points. I'm aware that because of constitutional technique to forbid judges from presenting their ideas through press releases should not be constitutional, but we have reached those extremes in which first we needed a law, now we need the Constitution in order to really comply with the ordering required by a rule of law. That's why we are amending some laws at constitutional level in order to put some order in this system. We have touched on Article 86 because, as you know, and as it was said by Mr. Botero in his discourse, we need to revisit the tutelas. We are not moving against them. We're just trying to strengthen it. It's a valuable instrument that all citizens have. But we have abused tutelas, and this is really hindering the rest of justice management. The Court of Antioquia, 75% of its decisions are based on tutela. So we are facing an exceptional justice, and we are hindering regular justice. Efficiency, we have changed the government body and management, and in addition to this, the other main axis is transparency, probity and transparency. We are increasing skills, requirements, and regulations to avoid the blockades in the courts because of appointments. We are removing election codes, and we are also raising the solution that was found by the Supreme Court of Justice in order to suspend a magistrate if there is bad conduct. We are transforming this, but by means of Law 5, all that process of political judgment is being reduced in time, and we are not creating another court because we do not want to have an additional court. The ideal thing will be 4 courts to modify the jurisprudence and not towards an instance court. We have reviewed the provisions of the Constitution, but in the legal reform, we are going to have a strong incidence on the fact not to have an instance court. This is more or less what the constitutional reform sets forth. We know we are going to reduce it, but sadly enough, we need to negotiate, or fortunately, we need to negotiate. I have to obtain a broad consensus in order for the basic thing of that reform to be approved. I'm not going to say that it's going to be approved. I mean, we're just starting a tough path ahead of us, which has been frustrated many times. And even Minister Esguerra, I mean, had a tough time there. I know it's a very difficult path, and I hope to complete it for the well-being of the country. At last, I would like to say that I have quite a challenge, Mr. Botero, and that is to design a municipal justice model. And I carefully read your speech, and I do think that in order to take justice services, or state services, I'm sorry, amongst them, justice services, we need to have a different presence in the territory and create some development poles. We are close to issuing the drugs comprehensive policy that is going to be issued next week. You know that we have an excess of illegal crops. Consumption of illicit substances has increased, and the ministry has to lead this integrated drug policy, and the idea is to take some special development areas in order for the state to reach that. I mean, it cannot reach the whole territory in an integrated manner, but in some special areas like Nariño, Catatumbo, Antioquia, through the Lower Cauca, and this is where we are having more conflicts, and that is where we have all sorts of crimes such as illegal mining and drug trafficking, and that's another challenge. But I think that with your speech, you're ratifying what I've been saying within the government, that we have to broaden the forest and jungle frontier and to create those new development poles. What will we do? I don't know. We're working in a responsible manner. I hope to survive justice reform and continue attempting this path. Thank you very much. I would have liked to intervene on these topics that attract me as the fly is attracted to honey. But in the interest of time, I'm just going to thank Mr. Solarte, who was the first to address the audience, then Mr. Salgar, that gave an excellent presentation, and my special thanks to the minister. When I listen to her, I learn new things, and I wish you much success, and thank you very much. Okay, this is an ad. I'm going to take some of your time to say it. Many things happen, and Professor Francois Bourguignon, who is going to arrive tomorrow for tomorrow's presentation, is not going to be able to make it. He is sick in Paris. He has fever. Perhaps in a tropical country he caught something, and that's why he is sick there. However, a Spanish speaker, Javier Salan Martin, is going to substitute him. Javier is professor of Columbia University in New York. He is an expert in competitiveness topics, and he is a great presenter, as many of you have had the opportunity to listen to him. So we are not going to have Professor Bourguignon, but we're going to have a keynote speaker who will come tomorrow. Hopefully you will all be present, the same for those who are not here, because we have made quite an effort to make the decision. I mean, it was midnight last night when we heard about the absence of Professor Bourguignon, so we've done everything possible for our friend from Spain to come. Now I'll give you the floor so you can close today's session.